Hi folks, and welcome back to Conveyancing. This is video 2 in the video series on special conditions. And in the first video we looked at classification of terms, conditions precedent, conditions subsequent, and subject to formal contract. So looking at construction of special conditions. As you can imagine, not all special conditions are drafted with the clarity and preciseness that one would always hope for. And that leads to the question of how often these things are declared uncertain and therefore unenforceable by a court. The answer is not terribly often. As I said in Meehan and Jones, it's going to be a fairly draconian approach of a court to declare an entire term of a contract, or for that matter, an entire contract, too uncertain to enforce. So, as I say on the little diamond there, the usual approach by a court is fairly receptive. Save that contract, see what we can look at that's gone on between the parties that we can enforce. There are a couple of areas that these issues of construction and possible uncertainty come up fairly regularly. One is where the term satisfactory to buyer is used. The other is the issue of approval or consent. In terms of special conditions, where the special condition relates to finance, you will often find a phrase, something like satisfactory to buyer, or subject to finance, or sufficient for the purchaser to complete the purchase. And I've just given you the little snippet from my REIQ standard form contract there. They use the sufficient to complete purchase formulation there. If you do fill out the reference schedule with that information in there, then you can see the little italic note there. Clause 3 will kick in, and it says that the contract is conditional on the buyer obtaining approval of a loan for the finance amount from the financier on terms satisfactory to the buyer. It then sets out the machinery of how things are meant to go down in terms of giving notice and whether or not you can terminate and who can and so forth. There was some concern early on in the piece that phrases like satisfactory to buyer or subject to finance or sufficient to complete were going to be too uncertain to be enforced. However, that's certainly not the case since the High Court's decision in Meehan and Jones. They frankly conceded that these kinds of clauses are essentially an option to purchase in the buyer's favour. They really do leave the door very wide open for the buyer to get out of the contract. However, in technical terms, the clause was sufficient for enforcement. The contract is not an illusory contract. You remember from your contract days that if a contract is illusory in the sense that one party has the complete discretion to perform or not perform, it's not going to be a sufficient enough arrangement. It will be illusory and it won't be enforceable. The court came to the conclusion that these kinds of clauses don't make the contract illusory, though, because a fully concluded agreement had been arranged between the parties, and once this condition is fulfilled, there is certainly no discretion on the buyer whether or not to perform. Once that condition is fulfilled, pending the fulfillment of all the other special conditions, that buyer is going to be locked into the contract and will be required to perform. So since Meehan and Jones, these kinds of things are quite common. In fact, probably more the rule than the exception nowadays in conveyancing transactions, given they cost so much money. What is the buyer's obligations here, though? Fairly minimal. The buyer has to, when they're deciding on whether the amount of finance and the terms are satisfactory to them, they have to act honestly. This is another one of those fairly rare times in contract law where you will get an obligation construed with a subjective element, so the buyer does have to act honestly in working out whether or not the finance is acceptable. They do have to go ahead and take reasonable steps to actually apply So it's not sufficient to pop one of these in there and then just not apply to any bank or building society or credit union or anyone for finance and expect to be able to get out of the contract. So you do have to take reasonable steps in terms of fulfilling your obligations there. What is less certain is whether the buyer has to act reasonably in deciding whether the finance is actually satisfactory. They have to act honestly, certainly, but whether they have to act reasonably, which is that more objective standard, what would the reasonable person say in the circumstances, it's not certain. I guess the bulk of opinion seems to be that they do not. However, it is by no means a settled matter at this point. So the ones that I've got in yellow are the ones that we are sure of that the buyer has to do. They have to take reasonable steps and go ahead and actually apply, and they do actually have to assess whether the finance is acceptable in an honest fashion. So that is the issue of finance being satisfactory to the buyer. Looking at the issue of approval or consent, certainly since Meehan and Jones, where a special condition makes a contract or terms of a contract subject to some kind of approval or consent, this will generally speaking be enforceable. It's not likely that it's going to be held to be too uncertain to be enforced. You'll often have requirements for approval or consent in finance terms, where the contract's to be subject to finance. In that respect, whilst making the contract subject to approval or consent is probably going to be enforced, where it comes to finance, you need to make a bit of a distinction between making your client's contract subject to finance approval and subject to your client obtaining finance. And there's a fine distinction that lies between those two terms. So where you make your client's contract subject to finance approval, once a financial institution actually offers your client money on terms that they haven't declined, then that special condition will be fulfilled. Okay, once the financier offers the money on terms that have yet to be rejected. That's a bit different to saying that the contract is going to be subject to your client obtaining finance, and there it means that not only has finance been approved, but the money's actually been made available to your client, and the text can flesh that out a little bit more for you further there, but certainly a distinction worth noting when you are drafting up this kind of provision. Where the approval or consent relates to some kind of approval or consent from a third party like the local government, you need to be very careful when you're drafting things up that you try and think forward to all the contingencies that might lie around the edges of approval or consent. So in the Richard West case, the contract was made subject to local government approval of use of the property as a hotel. Whilst planning approval was given for use of the property as a hotel, what wasn't anticipated was that the fire authorities were going to require a stack of fire equipment to be installed in the property, doors and so forth, and these were going to be quite expensive. Now the purchaser wanted to back out in reliance on this approval clause. It was held that they could not because the approval had actually been forthcoming in a planning sense. It was just that the other requirements that were imposed were unacceptable. So unfortunately in that case it wasn't possible for the buyer to back out in reliance on that approval clause. So that's the issue of approval or consent. And now we need to have a look at obligations, particularly best endeavours, reasonable endeavours, and so on, and time. So what does it mean when a contract says that your client has to use their best endeavours to ensure that something happens? Often you'll see similar formulations to this, like reasonable endeavours or reasonable steps. What does it mean? Well, if it applies to both parties, then it means that the parties have essentially promised not to hinder or obstruct, so not to prevent the condition coming to fulfilment. if one of the parties is meant to use their best endeavours, it means that they have promised to do their best to make sure that this special condition does materialise, and a failure to use those reasonable steps or reasonable endeavours, best endeavours, will be a breach, and it will mean that they're unable to rely on the special condition to escape the contract, cancel the contract. So it's going to be fairly important that they actually know what they have to do in terms of what best endeavours mean for them. The IBM United Kingdom and Rockwell Glass case is the one that you need to look at there. And essentially, someone under an obligation like this has to take all those steps capable of achieving the result that a prudent, determined and reasonable owner acting in his own interest or her own interest and desiring to achieve the result would take. Prudent, determined and reasonable owner. There's that harking out to the objective reasonable standard again. Acting in their own interest and desiring to achieve the result would take. So it is reasonable. It doesn't mean that you have to go beyond the bounds of reason in trying to make this thing happen. Okay, you don't have to go above and beyond the call of duty. You just need to do what is reasonable in the context in which the parties find themselves. So in Zeman Gregory, where the contract was stated to be subject to finance. Subject to finance, they only just applied for finance to one institution. That was not taking reasonable steps to procure finance. Okay, in that circumstance, in the formulation of subject to finance, rather than being subject to Commonwealth Bank, for example, finance, then they needed to approach more than one financier. The onus of proof is going to be on the person attempting to rely on the special condition. Okay, so touchstone there, if you think best endeavours, okay, it might sound a bit scary. Best, does it mean I have to do everything possible? No, it doesn't. The touchstone is reasonableness. Okay, so that's best endeavours. What about the issue of time? Most special conditions are going to contain a time by which the fulfilment of the condition has to occur. Ideally, it will be a date. And whenever you're drafting up one of these things, mental note, always try and put in a date wherever you can. If you do, it means that obviously the special condition has to be fulfilled by that date, and where time is of the essence, then it's going to have to be strictly adhered to. It's clearer for the parties what their rights and obligations will be flowing from the fulfilment or non-fulfilment of that obligation. If you don't put in a date, then you're thrown back into that horrible grey area of it having to be fulfilled within a reasonable time, which, you know, clearly is capable of endless dispute. So if you can put in a date, do put in a date. Sometimes special conditions are set by reference to the date of the contract. For example, finance will be obtained within 14 days from the date of contract. That in itself can be a bit confusing, because sometimes the date of the contract is not necessarily the date that the contract was legally formed. You'll recall that the date of contract formation, the time of contract formation, is when the seller, who's usually the last person to sign, communicates their acceptance of the buyer's offer. And so it's not necessarily the case that the date that the contract was signed, and often the date written on the contract, it's sometimes not going to align with when the seller actually notified their acceptance to the other party. So if signature occurred late of an evening, for example, and this wasn't communicated to the other party, to the buyer, until the next day, then the contract will have been formed when that acceptance was communicated the next day. So technically the date on the contract might not be the date of actual technical contract formation. And there's been a bit of just some disputes around this. The date most likely will be the date that's actually written on the contract, rather than the more technical time of contract formation. and the JLF Corporation and the RETEC case are the cases that you need to look at there. So that is the issue of time. If you've got one takeaway from this, please put dates into your special conditions wherever you can. So that is the issue of time, and that is the issue of obligations. The avoidance topic is probably going to take a bit longer than a couple of minutes, so I think we'll leave it there for this video, and we'll come back in our last video for avoidance and waiver. We'll finish on examples. Thanks guys, I'll see you in video 3. Now, today